Thank you so much, Joy, for the introduction. I apologize for I hope I don't have an echo. I apologize for my dress code. I'm somewhere in rural Kenya.
You're clear.
I'm somewhere in rural Kenya where I'd come to inspect construction buildings in line with my other work. That's why I'm dressed like an engineer, but I'm a lawyer. It's my pleasure to be part of this. I just jumped into a place where at least could be quiet away from the site, and I hope that I give a good representation of my people in the ADR sector. Will you project slides or I'll do them myself?
I think it's better you do it yourself, so it's faster that way.
Sorry. I don't have host privileges.
So just go to share screen, and then you're able to share.
Going 1 second. Just trying to retrieve my desktop and see which document to open. But now we see my desk without to. Can you see?
You can see your screen.
Yeah, I think I'm showing my entire screen. Give me 1 second.
So first open the document and then
go
to share screen.
Open document, then I share it. My apologies, I'll speak fast to make up for lost time.
All right, take your time. Yeah.
Okay, I think we're together. Okay, now back to my presentation. As Ribin has basically presented to in the first session, he discussed issues of contracts and basically how dispute resolution comes in. However, when it comes to dispute resolution, now there are 2 types of dispute resolution clauses we can have. On my part, I'm going to dwell on alternative dispute resolution, and I will restrict myself to negotiation and mediation because there'll be other conversations around arbitration. Now, when you hear alternative dispute resolution, you ask yourself, what is the alternative? Basically, what are we talking about? Basically, when you talk about alternative dispute resolutions, we are basically referring to methods of resolving disputes outside arbitration, outside litigation, to mean methods outside courts. Methods outside court. Perhaps apart from the contract that Ribin discussed in terms of how they are drafted, what clauses are very important in those contracts, you then would like to ask yourself, what is a conflict and what is a dispute? Another thing I'd just like to highlight is that we know that conflict and dispute are part of life. So long as they're human beings, even if you live in the same house, even those who came from the same mother's womb, even those you've done business with forever, at some point you'll have some points of disagreement or different goals. Now, conflict and dispute basically now escalate when parties or people, I'll say parties to mean when different people cannot reach a place where they can reach a common ground or agree. As such, there's nothing wrong with conflict and there's nothing wrong with disputes. The problem is how do we resolve, and where we can, how do we prevent them? So then now, those who know litigation, of course, you understand that litigation is basically court adjudication, and in court, there's a winner and a loser. However, for you to have a good conflict avoidance, conflict prevention, and even basically conflict management, you'd like to manage your conflict such that both parties feel like they're part of the process, and further that they've resolved the conflict in a way that is suitable for them and that is not violent, in short. Because one thing you should understand, even war is a way of conflict resolution, except that now war and fighting is at the extreme end of conflict resolution. So that's just something in mind. Now I need to point about these forms of alternative dispute resolution mechanisms. And by ADR, I'll be saying ADR to mean alternative dispute resolution. In this case, I mean, as I reiterate, it means processes outside litigation. I will not go into what can I say? I'll not go into the main, I would say off the top of my head, I can list at least 25 ways or methods or processes that can be termed as ADR processes. Nonetheless, I can only say this. The first thing is ADR methods basically in a nutshell can be grouped into 3 categories. One, where the first 2 parties, basically the parties just between the 2 of them, and parties can mean a company, 2 companies. It doesn't mean me and Joy only. Parties means the 2 sides of the conflict or the 2 sides of the dispute. So first methods of ADR is where the 2 parties basically just reach a conversation. They talk, try and negotiate, bargain, and eventually now come to an agreement. The second class is where you invite a 3rd party to oversee your dispute or to help you resolve, but this 3rd party does not have any decision-making powers. Decision-making to mean that they will not make a decision that now will be binding you like a judge would. The 3rd kind of ADR mechanisms is where this 3rd party still comes in, but now this 3rd party can make a decision, for instance, in arbitration. Nonetheless, the main forms of ADR that are common and are basically discussed in this jurisdiction meaning not even just in Kenya, even this area, East Africa, and perhaps even generally Africa, the most common forms of ADR are as follows. We have negotiation, we have mediation, we have conciliation, which is basically a form of mediation. We have MEDAB. MEDAB is basically mediation, arbitration. This then means mediation is, first of all, pursued, as in the way Ribin said in the contract. You can say, if a conflict or dispute arises, we'll pursue mediation and then subsequently but rather pursue arbitration if we don't settle. So that is called MEDAB. We have arbitration, which will be discussed in depth tomorrow. And then we have early neutral evaluation. I will focus my conversation around negotiation, mediation. And once you understand mediation, tomorrow when you hear arbitration, MEDAB will be clear to you. I'll just mention conciliation by way of passing. So then now at this point, the only thing I'd like to say about early neutral evaluation is where parties to a dispute seek a neutral party to look at their case or the nature of the dispute and give them an opinion, or what would say a reality check, so that they tell them, if this matter goes to court, these are the options. If you go to arbitration, these are the options. If you go to any other dispute resolution method, these are the options that you might have. So then now at that point, parties, instead of escalating their conflict, they then can decide to perhaps go back to the drawing board and see how they can reach an understanding as to the dispute. Now, the decision of an early neutral evaluator, that is the one who does the neutral evaluation, is not binding. It is an advisory decision. So it's for the parties just to test their case and their strengths and etc. And that's all I would say. Now, before I go to the forms to negotiation, I hope you can see. There's a dispute resolution spectrum. From what you can see on the screen, ADR, basically, this is how it is. As you can see here, we have negotiation, facilitation, mediation, early neutral evaluation, arbitration, and then we have litigation as the very last end, but litigation is not an ADR mechanism, of course. Now, as you can see this arrow, the further you move along the arrow, the more...
Mercy, yes? Allow me to interrupt you. Could you zoom out that page?
1 second. Oh, child. Is it any better? Okay. Is that better?
Yes. Thank you.
Okay. Great. So back to what I was saying. As you look at this ADR spectrum in short, as you can see what I was saying, when there's no 3rd party, when you're just negotiating, as compared to when you move to arbitration, it's an arrow. And the higher you go, the more these things down here happen. So then now, what do I mean to say? I mean to say this. Down here, when you're starting from negotiation, behind here, when you're just 2 and with no 3rd party or 3rd person coming in to help you resolve the dispute, you find that the process is more informal and parties have more control over the process. But the higher you go, the neutral decides the outcome and parties cede control over the process. And the process also becomes more formal and takes an adjudicative shape, as it were, to mean that now it starts looking more and more like litigation. As compared to down here, it is very informal, it is very consensual, parties have a lot more control as compared to an ADR method that is up here, meaning now the same thing with this arrow. If you pick negotiation, you'll have more informality, more consensual in terms of many things. Your outcome, you have more control and you have more control over the process. But if you pick arbitration, you still have the ADR, but it gets more formal and it more or less adopts the shape of a litigation matter. And of course, now the arbitrator being the third party neutral decides. So that is basically the ADR spectrum. Processes move from less informal, and the higher you go, the more formal they get, and also the more control you cede as a party.
My apologies for the interruption. Can you go to slideshow? Under slideshow, then you continue from this next slide. So it's going to be bigger so that people can see it.
I was hoping how to do that.
From current slide. Okay, we'll just go to the next one. Fantastic.
Sorry, 1 second.
Okay. Yeah.
Okay. Let's continue with negotiation. Now, sorry about me, just excuse me. I'm just trying to
take your time.
I think I'm ready. My end is sure. I want to just, it's best if I start from the current slide. Yes, great. Okay, here we go. Now, I'm having quite a challenge. I think it's
go to end the show. You can end the show, go to the slide on negotiation, and then from current slide, yeah.
I'll live with myself, I think. Okay, now what I'd like to discuss, to just highlight to the attendees on negotiation. As I said, negotiation does not involve a third party. It is two parties, or it could be two companies, two people, a person and a company, an employer, employee, basically two people or two companies or whoever might be, because sometimes you're not just, it's not two actual people, it's you and a company, but the two sides of the dispute, where they go and try and reach an agreement or settle their dispute without involving a third party. Now, I would just like to focus just slightly, because as Abayomi would tell you and anyone else, for you to now get into a whole negotiation class, that might take even months for you to now understand, because negotiation is not as simple or as light as people might like to assume. So then now in this case, when I discuss about principal negotiations, I just like to highlight that this is the negotiation where you find parties wanting to stick more on objectivity and not dwelling so much on the relationships, if you understand. This is to mean what? For instance, you might be very surprised because most of you people are SMEs, and I'm sure when you're getting into your various contracts and discussions around setting up your businesses, you do get into contracts for supply of goods and etc. By the time you're getting into a contract with someone and perhaps you've worked with them for quite a bit, it stops being just I'd say a commercial arrangement, and it also now becomes a personal relationship. And a personal relationship also means there's an amount of trust and there's an amount of familiarity that you more or less get with this person. So then now, principal negotiation is the approach where if you're in that contract or in that dispute that has arisen with someone, instead of looking at other subjective things like maybe you've been doing business together, trying to understand why would this person perhaps breach the contract, trying to also understand why your payment is not coming in. In short, even an employer understanding why the employee did this or vice versa. So then now, principles, it's mostly on objectives. However, when you want your principal negotiation to work, the best way is to have an integrated approach. And I can say this, an integrated approach means what? You separate people from the problem and you try and have an objective look at the problem. Second, you also now see how to look at the interest, because as I said, you'll be very surprised that sometimes what might be perceived to be commercial disputes have actually nothing to do with the shillings and cents. They have to do with the relationship between the parties. And when you can find a way of sort of healing or curing the the interest and the relationships. The commercial matter, this follows in like the shillings and cents now. I have done this and I have seen it happening. And also, I believe that instead of sticking to your goals, it's better off if you look at also interests so that you have a successful negotiation. Now, how do you prepare for a negotiation? You have to determine, of course, what you want from the negotiation. And I'm not saying it is advisable, but I will also not force anyone to do what they do not want to do. You have to decide, do you want to stick strictly to the contract in terms of having it, I'm sorry, it's raining here, so I hope it does not disrupt my voice. It's raining heavily. So you have to discuss, first of all, with your team or decide on your own whether you're the kind of person who wants to go into a negotiation, hoping also to keep the relationship, or you want it to be purely based on the breach of the contract. You also have to think about which team you're going with and who are you going with. Think about what interest you really have. And at this point, I'd really like to encourage, be honest with yourself, because as I said, sometimes what might be perceived to be a commercial disagreement has nothing to do with commerce. It's a lot to do with relationships, and even things like perhaps someone even just rubbed you off the wrong way. You need to identify what really are the issues that you want to go and negotiate about, because without a goal in negotiation, you'll find yourself talking with a person for 10 days, going round and round, and there's nothing really that you're getting to. So you have to know this is one issue, so that when you put out the issue to the other party and say, okay, what about the breach of contract? Can we discuss this? What about money? Do you think you owe me, or vice versa? And even in terms of interest, will we have interest on this amount? Will we do the normal bank interest? Can we negotiate on interest? So you have to know what issues really you want to negotiate around. The other thing is also determine your partner. Now, your partner is the best alternative to a negotiated agreement. In short, when you go to a negotiation, it's not cast in stone, or it's not a matter of life and death that you'll have to reach a settlement or agreement to the other side. Now, knowing that, once you leave that negotiation table, there's another step you will take. Now, in the hope of resolving this dispute, you can decide to go to another ADR method, or you can decide to go to court. Now, when you're looking at what your partner is, your question will then be, if this negotiation does not work, and I have other options, are those options better than what is being put to the table here? So then now, for instance, it's an agreement, it's for instance, someone who, a car loan, yes, so let's say it's a car loan. And then in this car loan agreement, one person does not pay the full amount. So at the negotiating table, the amount owed to the seller is about $3,000. Then there's another person who'd been talking to the buyer, to the seller, and saying, if you can bring that car, I can give you 5,000. So you see, the seller at this point has a better partner. So that if you cannot give the seller the 3,000 on the negotiation table, whatever alternative they have is better. So that is a partner. Think of your best alternative if you do not settle today, and think, is it a strong partner or is it a weak partner? Because that will also make you think and perhaps move around your options on the negotiating table. Of course, you have to research the other party and think about what deals you might be thinking for, and start thinking of mutual official proposals in advance. You don't have to necessarily write them, but as with everything in life, I always say, preparation is a must. So I basically discussed partner. Now, partner is the opposite of partner. So that in a negotiation, partner is best alternative to a negotiated solution. Partner is worst alternative to a negotiated agreement. So then now, if you're going to a negotiation, you need to know what your partner and what your partner is. So then now, this means if you do not settle on that day, your partner is your worst alternative if you do not settle. Also know your best alternative. So then now that will help you know how to move around the negotiation table. Of course, how do you develop your partner? It is in line with what we've basically highlighted in the earlier slide. You have to, first of all, know your case, know your dispute, list your issues, research the other party, formulate options, and now, how do you develop the partner and partner, especially the partner in this case? look at the options. For instance, if it is in this example I've just given of a car loan agreement between a buyer and a seller, the first thing you ask yourself, for instance, some of the options would be, can I keep the car and perhaps pay $100,000 or $1,000 more apart from the initial fee? Or can I use the car for a few days and then the other days perhaps I use it for Uber? You have to have all your options, because once you have your options, you will have more options at the negotiating table. So then now you can move around pieces and see how you can settle. And also, if you have a partner, you'll also be able to negotiate properly and improve on some of the options that come up, because you know what you have and you know whether it can be made better. So then now it becomes a strong partner, or maybe you just know now it is not as good as I thought, and now perhaps it's time for you to think about settling. So you have to develop different partners, of course, to then basically get more options to the negotiated settlement. So then now you know which one is the best one of them all. Just general skills that I'd say in negotiation. And this is something that I must just say. What I've observed in negotiations, not myself so much being in them, but perhaps teaching in, so never say where I peeped through negotiations, but here we are. You'd be very surprised that the things that matter to the other side most of the times is not so much the law or the facts or even the actual agreement. It is how you treat the other party. And as such, rather, in line with that, one of the things that is very important is communication. And communication is active listening. Active listening is where you actually give someone your body, not your body language per se, you give someone your full attention, and also how your body language is. You see, if someone as human beings, if you know someone is really talking to you and interested in your business, there's eye contact, they nod, and then of course your body kind of tends to lean more. These are some of the tricks also, so that you appear open to the other side in a negotiation. You lean forward. You have also to keep a relaxed body, relaxed shoulders, don't be too tense, smile more, eye contact, so that people can be open in a negotiation. So that's now the opposite of active listening is passive listening. When someone is really telling you why they think you should reach an agreement, or why maybe they're not pleased with your behavior, and then you're seated with your arms crossed and you're looking away, picking your phone, you'll be very surprised that such people who exhibit passive communication do not go far in negotiations, because negotiations also are about respect. You have to acknowledge what is being said. And this means when the conversation try and keep, not really mental, but it's something you have to perhaps learn how to do. Acknowledging means when you move further in the negotiation, for example, 2 hours later, you can say, okay, in line with what you said earlier, this and this and this. This also makes the other party knows that they've been heard. And also you have to acknowledge and say, okay, yes. When someone says, that day, this contract went this and this, you breached this contract, I was hoping you'd pay me on this date, but you did not. You say, okay, I hear you and I agree. And I acknowledge. You have to acknowledge even emotions. Actually, when people say they are mad, because some people say, I'm really annoyed with you. You don't say yes and I don't know, yes. You have to acknowledge. And acknowledgement of feelings and emotions is basically, you say, I hear you and I understand how my behavior could have upset you or made you a certain way. And then moving forward, but now we are here, we would like to move forward. Acknowledgement is very important. And also do not just be those people who listen. So then now when the sentence ends like this, you want to jump in. That is not a good communication style, and it certainly will not get you far. Do not make insulting offers, that's for sure. In the same example I gave of a $3,000 perhaps balance in a car loan agreement, you cannot start saying, now me I have 500 beginning and end. Surely, sometimes don't make some offers that you know are just low ball offers. And that's why we said you have to look at all your options and come with options. Because I could say I'll give you $500, but then I know a person who's coming who is willing to buy this car for 5,000. So when I recover, I'll give you the 2,500. But now you can't say 500 beginning and then don't insult the other side. Don't speak at people, speak to be understood. Try and calm yourself down. Avoid name calling, inflammatory remarks. I told you many negotiations have backfired and died at the altar of ego and insults and poor communication. Of course, create an enabling environment for negotiation. You realize that negotiation being an ADR method, which I will highlight towards the end, is private. Try, and enabling environment means since it is not a court of law, you have a lot of wiggle room. Pick a venue that is comfortable. Don't be going to busy restaurants, maybe where you have to whisper. Find a place even like where I am right now in rural Kenya. Just go and sit in the forest or somewhere in the park so that both parties are comfortable. Try as much as you can also pick a neutral spot and where both parties feel comfortable, so that if I don't want to come to your office, don't come to mine. It's okay, we can get somewhere. Speak about yourself, not the other side, for sure, for sure. Don't purport to understand the other side and what they feel. And that's why in the example of acknowledgement, I basically emphasize that you do not say when someone expresses an emotion like anger or disappointment, you say, no, I know what you feel. You do not know how they feel, just acknowledge that I know how that could make you feel, or I know my behavior could make you feel like that, because you do not know how the other person is, and you cannot now start purporting to speak to the other person. Avoid, of course, blame game. Do not also start condemning the motivation or intentions of the other party, saying, oh, I don't know, you are wicked. I know you've been planning this. You'll not get far with that kind of language. And of course, speak to a purpose or for a purpose ties in with basically what I said. That is why you have to come to a negotiation, having planned. A negotiation, you just don't walk in. That is, people assume it's easy, but if you want it to be as successful as possible, and especially this being what we're talking about, SMEs, and you know, most of this arise from contracts, you have to go well prepared, because if you have your list of issues and you know what you want, you'll get into a negotiation intentionally, not just going and throwing things all over. You'll have no purpose, and in short, in end, you'll have nothing. Now, back to the zone. Increasingly, I'll speak about this, the zone of possible agreement. This is a bargaining area, and I think this is, most of us have been in a negotiation where two or more negotiating parties may find common ground. Basically, in short, most of us who are in Kenya or Tanzania, basically, you've seen how cars in traffic behave, or drivers rather in traffic behave in their cars. If two drivers have a small fender bender in traffic, one says, oh, I need 10,000 to repair the car. The other one is like, honestly, January, you know how I enjoyed Christmas, so I only have 2,000. So the zone of possible agreement at this point, where is the zone? The zone is 10,000 Kenya shillings and 2,000 in between there, common ground. Somewhere in there, that is where the zone of possible agreement lies. Now, I hope I try to speak as fast as possible, so I'll quickly move on to mediation. I hope negotiation is fine. Now, as I said in the beginning, the three types of ADR methods, basically, they're not the three types. ADR methods can be grouped into three types of dispute resolution methods. There's where there is no third party. There's a second one where there's a third party but does not make decisions. And there's the third where there's a third party who makes decisions. Now, in this case, negotiation, it's parties amongst themselves trying to reach an agreement or to settle their issues. Now, the middle one is where now this third party has come in. And in this case, I'll go to mediation. Mediation, there's a third party here. Because now after those castle agreement people, these two people who perhaps had a fender bender in traffic have not managed to reach an agreement, unfortunately. So they get a third person and go to mediation. I'm a bit biased because I'm Kenyan, but I will quickly highlight where mediation we can say has been anchored in Kenya. I will refer to the Constitution of Kenya, Article 159(2)(c), which basically allows the judicial officers and the judiciary generally to employ alternative dispute resolution in resolution of disputes by courts and tribunals. And of course, one of the methods listed, under Article 159(2)(c) is mediation. And of course, what now we call court annexed mediation, court annexed mediation program, yes, that is anchored under the mediation pilot project rules of 2014. Why pilot is in brackets is because when the first court annexed mediation started in Kenya, it was pilot, but now it is a permanent process of the court. And then, of course, under our Civil Procedure Act, Section 59D, and this is something perhaps people really need to understand, because I don't see Kenyans taking advantage of this, because this came actually and was always there even before the new constitution. In short, here, it means if you have a dispute and you go and settle it through mediation outside without court assistance or anyone's assistance, so long as you just got your own mediator, even if it's your chief, so long as you reduce it into writing, you can take it to court under section 59B and D rather, and the court will actually adopt it as its own order, like basically as though it was the one that oversaw that dispute. Now, understanding mediation, basically, to understand how mediation is different from negotiation. As you can see, the first point is that mediation is an assistant form of negotiation. As I said, this is now where the third party has come in. And I'll just quickly speak on what are the pillars of mediation. The first one is that the mediator is a facilitator or helper. The mediator is not the person who makes a decision, and the mediator will never make a decision. 2, it is voluntary. No one forces you to go to mediation. Only in court annexed mediation are you now compelled by the court to go for mediation. But even in court annexed mediation, and when I say court annexed, I refer to Kenya, you are not forced to settle. You are only forced, or rather compelled, to go and try mediation. So still it retains its voluntary character. So that mediation is voluntary. The mediator, of course, is a neutral and must be neutral, impartial, and independent with no connection to the subject matter. And in fact, one of the things that has made courts and even other tribunals, let me use lay language, refuse mediation agreements or basically dismiss the mediation agreement is where a mediator has been found out to be impartial, that is biased, or not neutral. So a mediator must be neutral and should be neutral, and is usually neutral 99% of the time. And where one is not neutral, that agreement will not be adopted or considered valid. It is also party-driven, and party-driven, I mean that parties basically are the ones who agree to go to mediation. Parties are the ones who sit in mediation, because 95% of the times, parties go to mediation themselves to mean this. This is not like litigation where you take a lawyer and the lawyer goes and presents you. No. You are represented by yourself. You go on your own and you sit in mediation and speak. Even in commercial mediations that involve companies, it is the CEO or the head of legal or someone who not only understands the matter, but someone who can speak directly. So then now there's that. Also, it is parties who have control as to how the mediator is chosen or how to choose a mediator. Mediation is also private and confidential, because only people who have direct connection with the dispute or are in the dispute sit in a mediation. It's not like court today. I can go and hear, oh, there's a divorce. You go and listen. You can't. Mediation, it's either you're the mediator, one of the parties, or you have permission to be in that room. And all these characteristics of, apart from having a mediator, all these voluntary, party-driven, privacy, all those also apply to negotiation. Now, how do you find yourself in a mediation? As you can see here, parties can agree in the agreement, as Ribin was discussing about contracting and how you draft contracts. In your contract, you can agree that once a dispute arises, we will go to mediation, and now say how you'll appoint the mediator and how many days perhaps you have for the mediation and all that. Second, when now you go to court, and this is 2 ways, mediation you can end up in mediation from court in 2 ways. When you're in a litigation and the matter is already continuing, and the court finds it prudent in its wisdom, and the court means the judge or the magistrate, to refer you to mediation, so that you go and attempt to settle this matter, because in his eyes, he can see, or she can see, that this is a matter that actually these parties can talk out in the presence of a third party and agree. That will save them time and costs. 3, the second way a court can now move a matter to mediation is like, for instance, now in Kenya with the court annexed program, where all matters in employment, land, children, matrimonial property, family, any matter that is filed under those issues in courts of law in Kenya have to go through a screening system. And a screening system is to establish their suitability for mediation. Commercial, civil, if a matter has protracted, like has taken long in court, or upon screening it is found that it is a matter that is not too complex, a court will refer an already filed matter now to court annexed. So that it is either a matter that is continuing and we are told just go and look for your own mediator, try mediating, or court annexed, where now the court gives you a mediator and you try mediation under the court's mediator. Requests by a party in litigation, those of you who've had lawyers or have seen how court happens, even during litigation when you're in court, parties can agree themselves or even through their lawyers to request that they be what lawyers say, you're giving, let's go and negotiate. You go and get a mediator and try to mediate. Those are the three ways. Now, as I said, appointment of a mediator, it can be ad hoc or institutional. Ad hoc, it basically means okay, maybe I should start the other way around. Institutional is where, for instance, in Kenya, the Chartered Institute of Arbitrators is very popular as an appointing authority. So you decide, let's do an institution. But then in Kenya, Chartered Institute of Arbitration does more ad hoc. Ad hoc basically, okay, let me just say this. Ad hoc means there was no provision. You've ended up in mediation, but you had not mentioned an appointing authority and such. So then now, for instance, the example of ad hoc is institutional in Kenya would be the Nairobi Center for International Arbitration, because the Nairobi Center is an institution. And when you appoint under the Nairobi Center, they administer the mediation. So they assign a mediator, they pick the money to pay the mediator, a lot of control in terms of administering and running the mediation. However, ad hoc, it is just parties, you go to them and tell them, just appoint for us a mediator, as usually is the case in Chartered Institute of Arbitrators. They pick a mediator, then the mediator continues with the mediation. Chartered Institute of Arbitrators does not oversee the mediator or mediation rather, or pick monies or help. It's just the way it is. You pick, you write your institution, whether Nairobi Center or an institution now to administer, or ad hoc. Party or third party selection of mediator, of course, this means parties can agree that we'll pick Okiro to be our mediator, or if parties can't agree, there's a default person now who will pick for them a mediator. And usually in Kenya, in most places, it's usually Chartered Institute of Arbitrators, Tanzania Institute of Arbitrators, and such. Of course, mediation agreements, how you're preparing. Once you've appointed a mediator, you have to see, according to your contract, who is appointing. Is it ad hoc? Is it an institution? Do you have to agree, or do you now have to get a third party to do it for you? You also have to look at the mediation agreement in terms of where has it arisen from, where are you getting this basically mediation? Do you have a mediation agreement within a contract, or is it verbal? Because sometimes you may not have a mediation agreement in a contract and you just agree either way, let's try mediation. But then just to be sure, it's best you write a separate agreement of a dispute arose under this contract and blah, 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 we decided to go to mediation. You have to write preparation of brief written statements. This is depending on whether you want to write or not. Personally, I find that writing or not, the thing is at least come with your summary, have your summary of the background of the dispute, and also perhaps what issues are irking you or issues that you see would perhaps you want them addressed. Mediators' fees, depending on whether it's institutional, it's just good to understand, because mediators are paid per hour. This is not negotiation. Now this is a third party, and unless if they are doing it for you pro bono, one, that is free, or two, if it is court annexed where the judiciary pays the mediator, know the hourly fees, know how they should be paid, and get estimates and prepare to go over and above a few hours, because you don't know how long the matter will take. Of course, observe and apply the same preparations in inter-party, knowing your case, knowing the other side, having some, of course, an idea of what you want in terms of a deal. Also, communication is still the same way. In fact, in mediation, it is now 3 people who have to behave themselves, both parties and the mediator. Even the mediator's behavior, the mediator's demeanor, how the mediator treats both parties is also important now, because this is not a two people matter like negotiation. So even a mediator communication, some of you also can be mediators. And you see, a mediator does not have to be someone who's trained like me. A mediator can be 2 SMEs going to get the CEO of another SME. Whenever you sit in that mediation seat, you're bound by those communication rules. Be friendly, be kind, try and get people to feel relaxed, because when people are more relaxed, that's when they'll open up. So the same communication skills and active body language that are necessary and are encouraged highly for a successful negotiation apply here, not only just to the parties, but also to the mediator. How a normal, these notes will be sent, but mediation, I don't really think I need to go word for word. I'm just taking the time so that I'm sure I'm not too behind. Opening, basically when you enter into a mediation, the first thing that is usually done is opening. And opening is this: the mediator introduces themselves, introduces the parties. I'd rather the parties introduce themselves. How you sit is one thing, so you have to decide. The best mediation sitting style is usually a round table, but sometimes you don't have an option, so you have to have the right and the left. So even who sits on the right and who sits on the left, be very sure that that conversation has been had, because it can be very problematic if you go and sit people and they say you put me on the left because the left is the weaker hand. So such things, be sensitive to them. Of course, after introduction, you have to explain the process to parties so that they know what is expected of them and what they need to do, and what also they should expect from you. Of course, ground rules. Otherwise, people will run amok. You have to set ground rules, things like use of language, use of electronic devices, recording, which is prohibited. You need to set ground rules. After that, then you invite parties to give an opening statement. And an opening statement is not that now they're in court, they have to be so formal. It's just people in their own words giving you an understanding of what the dispute is and what they assume to be the cause of the dispute. Now, in this case, everyone in the room, even if it's a lawyer and a lawyer and clients, SME, lawyer, whoever, ensure everyone speaks during the opening statement, because if someone keeps quiet, and generally in a mediation, ensure that everyone has a fair chance to give out their views and participate, because sometimes you might be going to settle and then one party says, I've not been given a chance to speak from the beginning, or they say you are not partial or not neutral. Just ensure also understanding as a mediator, you also have to understand. So then now after opening statements, you need to regurgitate back, and not like now you repeat. You need to regurgitate what you had and what you understood by the opening. Parties know that not only are you capable, you are hearing what they are saying. Of course, the next stage now is information gathering. After you've done the opening statement, now probing is asking open-ended questions. Okay, why do you think this SME breached the contract? Why do you think the party has not treated you well? How do you feel after this about your relationship moving forward? How has this, for instance, how has this dispute affected your nature of business? Active listening, as I said, I'll just reiterate in passing. Caucusing is and get an understanding of the dispute, because sometimes before parties can be very open, they then can be closed off. So you have perhaps to caucus. Caucus is where the mediator, sorry, I thought my phone is going off and it's the one offering internet. That's why it looked sideways quickly. So a caucus is where the mediator goes with a set of people on the side in a confidential sidebar, as you are, to discuss things that might help the mediator unlock the dispute. Now, a caucus may be between any set of parties. It might be between me, the mediator, and the two parties, me and the two lawyers, me and a lawyer and a party, me and the brother to the SME, to the loan guarantor. So long as during caucus, whatever is said, a mediator is not allowed to tell that information to any other party without permission from the ones who told the mediator that information. So, of course, that's where now I say disclosures and consents. Those are things that you have to know. If you're in caucus, feel free to speak, and your mediator must then assure you before and after you go to caucus that whatever he's told or she's told, they'll not use it or tell someone without your permission. Of course, information gathering, that's when now, when people are relaxed, they will tell you more about the dispute. And then now that is when you can move to identification of issues, because sometimes issues may not be what people have really written. Issues might be something behind that they do not want to say. For instance, someone is jealous that their business partner bought a new car or has bought a new house. So that's on issues. It's yes, this business partner stole the money from the company. But when you actually explore, you find that it is deeper. Maybe this other person also insulted them after they bought the new car and called them a dirty, poor dog or whatever. This is just my own example. So that's when also during information gathering, that's when you also get deeper. And since a trained mediator is a trained mediator, as you're moving deeper, that's when you also come to understand that some things, there's some interest behind it, and also you learn about their position. Because rarely do people in a mediation come and give you all their positions and all their inner secrets. So it's up to you. Now, bargaining, of course, it is caucusing. In caucuses now, that's when you hear things And over time, as you conduct the mediation, parties will start saying, okay, you can go and give them this offer. We hear what they'll say and vice versa. So of course, there's a lot of exchange of offers. Deadlocks happen, and deadlocks is where people say, this is our take, beginning and end, we're not moving. It is what it is. Well, we'll discuss just in the next slide how to break deadlocks where parties seem stuck and you feel like you've hit a wall. However, now the last stage is conclusion, of course, where now parties agree on points of agreement, disagreement, clarity as to contents of agreement. As I repeated, in every mediation, even at the time of drafting, ensure that every party in the room says, yes, this is what I agree to. You'll be very surprised as to how settlement agreements have been set aside because of that issue where you tend to have one party feeling like they were not, they did not participate fully in the process, or they did not write, or they were not part of writing the settlement agreement. Deadlocks, here we are. Of course, it is basically where parties don't compromise and everyone else seems like they are stuck to their position, and that is the end. Not to worry. This always happens, so it's not too crazy. It happens and we have recovered. The causes are usually, of course, as you can see, unrealistic and impractical expectations where a party thinks they deserve more than they want and they feel like they cannot go any lower or change because they feel like they're in a better bargaining position. And of course, pride, we are all human beings. So as you can see, pride, emotional baggage, those two, of course, they emotions generally can cause people not to want to budge in their position. There's also insistence on bottom line. This is something I've seen, and I think, I don't know that it's from too much TV, but also it ties in sometimes with pride and ego when people come and say, this is my bottom line. This is our bottom line. There's no bottom line, let me tell you. And others, it's a stalling tactic. When you know you don't want to settle because maybe you want to go to court, or maybe you just want to frustrate the other party. So you pretend you cannot budge so that this now mediation stalls, and then for whatever reason you stall, now you can pursue your other side businesses. Yeah. So how do you break deadlock? Quickly, you take a break. Sometimes in a mediation, people are tired, they're hungry, they've been there, they've thought so much. Give people a break. In fact, that's why it's good to have mediations in places where they even parks, umbrellas, they can just go and sit, have a coffee. Also offer parties snacks. It's usually a good thing so that people are not hungry, because sometimes when your sugar levels are low, you feel like you don't even have energy or even don't want to move. Humor, of course, but humor, you should be very, very careful about it, because my sense of humor, and mine also is very weird, is not the same as everyone else's. So if you're going to use humor, you better be really sure, because also there's a joke that can upset everyone or whatever, upset one side. Of course, allowing parties to express emotions, that is actually very important. Sometimes you can see this, people want to say something, but they feel like they can't say it in front of others. And it's not something per se, it's they need to let go of something. Look for that, look for cheap concessions, of course. Small things like what I said in terms of the same example of the sale agreement of the car of $3,000, saying, okay, but my cousin is willing to buy the car for $4,000 even. So how about I give you $500 today? Then in 2 weeks when my cousin says, in fact, I'll give you the 4,000, or I'll even give you, I'll pimp it. Before I return it, I'll pimp it with a new stereo system or something. So small things that you may, based on now exploring with the parties, may not look like that important, but really matter. A very small thing can change. Some issues drop, because sometimes, and in fact in mediations I found when people really stick on the shillings and cents of no, moving, sometimes shelve the shillings and cents conversation and go back to the nature of the business. Okay, so how has business been? And then over time, people tend to relax, and also now they tend to tie in the value of their prior relationship, business or personal, to now that amount, and then now it might look more. But if people jump to, and actually even when mediating, avoid jumping into the shillings and cents conversation too fast, because if you mention it too fast and you get a deadlock into, shillings and cents are tangible. It's 50K, it's 50K. Another one, if it's 20, it's 20. And someone now can see how the 50 is getting 30, 20, and the 20 can see it going up. So try and do as much as you can, because the shillings and cents conversation can also be a problematic issue, but drop some issues if you can. Of course, ask the parties to also bring them together, ask for their suggestions. This is also sometimes where you break them up and ask them, okay, not break them up per se, you just separate them and ask them separately what suggestions do they think would be accepted. And this is, of course, now ties in with reality testing. Reality testing is where now you don't act mad like you're angry, but it's just a way of showing the parties actually, now we're getting to this place and it is your mediation, and would really, my work here is not to reach a decision, but to assist you. So the decision has to come to you. However, right now it appears that there's not so much compromise. And tell me, if this, from here, what would be your next avenue if we do not settle today? Second, if you are to go to court, how long would it take? What are the remedies that you will get? What are the chances that you'll get what you want out of here? Do you understand whether or not you have control over this matter anymore? Such things. So that part is now there. Like, how strong is your case really if you were to go and take it to arbitration or litigation? So such things, you test the reality. So that parties can now just start rethinking of how to reformulate their conversation and solutions. Okay, I'm almost done. So the settlement agreement, for those people who've not drafted a settlement agreement, in Kenya, you can go to the Mediation Pilot Project Rules under it's online really, Mediation Pilot Project Rules of 2015. There's a sample, and also online there are essentials. However, the things that really should be essential, apart from this that you can see, who prepares it personally, I'm not too pressed, but if you have a representative, good for you. The things that I would say are a must is signatories, anyone with authority to settle. And authority to settle, it means this: you either are the one who entered into the initial contract, or you are the person that, if you are the one signing this contract, this mediation settlement, you actually can be a person to be with powers to enforce it. An example is this: when you have a company, you can either have a director or the CEO with authority from the board of directors, because sometimes you can find one director coming for a mediation and they sign, yet there was no authority from the entire board or the entire director or whatever, from the core directors. And then subsequently, they go and say, as we do not agree to this mediation and this settlement. So anyone who is affected by the outcome of this mediation agreement, please, they must sign themselves. And when a person is abroad, I have had people do agreements and stamp them, and even notary in court, have them done, whatever, notarized, sorry, to ensure that they have actually agreed that this other person can sign on their behalf, because this is problematic. So ensure everyone must sign, including even the lawyers, of course. As to mediator being called as a witness, that one, the mediator, now it is up to you. If it is not in the rules that you choose, like SIAB, the Chartered Institute, or Nairobi Center for International Arbitration, you can just say, I cannot be called as a witness if this matter subsequently goes to court or arbitration. Parties' agreement, of course, must be reflected. And of course, as I said, all parties check every clause, check. At the time of signing, check that what is agreed. Everyone says, yes, this is what I said, and it is the end. Of course, enforcement now, after that, depends. You can decide to include enforcement and say this mediation settlement agreement is not, if any parties deviate, this is what will happen, or you just let the law take its course. Like in Kenya, it can either go to court as a contract, now you go and enforce it, or if it's coming from court annex mediation, the judge will, basically it's an order of the court, so enforcement is up to you. Or also if it's Nairobi Center for International Arbitration, you see how enforcement is under there. Sorry. Now, after all this talking that I have done today, this afternoon, what am I trying to say? I'm trying to say this: SMEs actually should, in my opinion, should be the largest consumers of ADR. Because why? In Kenya, and I will give an example of Kenya, and I'm sure it applies to SMEs, because SMEs are basically, they have the same shape, they are the same animal of Africa. SMEs, it's not just one contract. They get involved in licensing, employees contracts, commercial contracts, everything, licensing, regulation. There's so much contractual work happening in SMEs, such that if they were to think about dispute resolution, it then means a good number of disputes are also coming from SMEs. And now SMEs also means they are not handling billions of dollars. That is why they are SMEs. So then now, one, an SME's work is the work that it was incorporated to do. And second, to make profit. Now, when an SME gets sucked up in so much litigation and so much dispute resolution, it becomes a small court of law, which now is no longer the core business of an SME. So then, second, when you think about even on the litigation aspect, it is this recognition that has even caused the judiciary in Kenya to bring the small claims court for matters of $10,000 and below, because $10,000 is $1 million thereabout. I'm just saying in dollars. So that's, yeah. So then, if courts can do that, what about your own selves as SMEs, and why ADR? ADR is faster, and I'll give an example. Faster in this case, an average court matter in Kenya today takes about 5 years to be completed, honest, and I'm not lying. Mediation, court and next mediation is 60 days maximum. I have done about 40 mediations now, not just court mediation. Okay, more than 40. Wow, it could be 70 actually. And I've not taken more than 3 days in any mediation ever, even the court, never. But then now you see you can mediate day to day, but then collectively, no, so it is faster. It is less costly. Mediators are cheaper. I'll not lie to you. They are not paid as much. And you see in mediation, you don't have to pay a lawyer, because mediation, you don't need any legal help. You're going to speak for yourself, and the mediator's work is to facilitate. And so it is less costly when you think about it as compared to all other, even arbitration, as compared even to litigation especially. And flexible. Flexible, as I said, you choose the mediator, you decide how the mediation will be conducted, you can agree on where, you can agree whether, which language even, you can agree how the agreement, what you want the agreement to cover. In mediation, you can also be very flexible in terms of the terms. You see in court, some things the court cannot accept, but in mediation, you can get into other agreements so long as they are not illegal, even agreements for exchange of cars, such things. So it is very flexible and adaptable. And also it is less technical, because mediation, anyone can sit in a mediation. You don't have to have any understanding of the legal process. And more importantly, you don't even need legal representation, and that, of course, subject to a good mediator. So another thing, it is private and confidential. As I always say, companies like Safaricom, you'll find that they have ways of resolving their own disputes such that you'll rarely hear very serious allegations or very serious court cases in Safaricom as compared to many companies. No companies are in the business of making money, even SMEs. Even when you're taking your loans and whatever, even in terms of applying for loans, grants, and even funding. Now, if it is known that you're always in dispute, do you really want that to be basically your company's reputation? So it is private, it is confidential. As I said, consensual. No one, the voluntary nature, no one forces you to go. It is for you to agree. It is party driven. Of course, as I've said, parties have a lot more control. Also, it looks at interest-based issues beyond financial issues, and therefore preserves relationships. This is to mean mediation does not just look at shilling cents and the contracts, it also then moves to issues of interests, so that now, is there something behind this dispute? Is there really something behind breach of contract? Can I move around this issue, not just looking at the shillings and cents perhaps, and also preservation of relationships. And relationships, I don't mean personal. I said even business relationships are business relationships. Like Abayo, me and I have done business for the last 4 years. So now we have a relationship. So now even if we were to go to mediation, we cannot just say that it is pure business. We have a business relationship aside from what is on paper. Of course, the less technical nature, and I think that helps. My part in short, and it's a quiz, but not really, it's when you look at this photo on the screen, how many animals can you say you see? Me, I see 4, others see 2, others see 1, and you can see, so that is the whole nature of conflict and dispute. They are part of life. So that now me who's seen a rabbit, the other one has seen a duck, does it mean either of us is wrong? All of us have seen what we have seen, but then none of us is more right than the other. So conflict is part of life. We just have to pick the best way of resolving it. Thank you for listening, and I will stop there and move to questions. Back to you, Joy.
Thank you very much, Mercy, for the incredible presentation. I'm sure everyone has learned so much, and you've covered so much in a very short time. So we will quickly move to the Q&A session for 15 minutes. Bayomi, I had lost connection for some time, so I do not have all the Q&A, all the questions rather.
Okay.
Please help me out.
Sure. 1 second, let me just scroll down to. Okay, Dr. Patrick Survey has asked what ADR clauses in contract should we mediate, arbitrate, or litigate, and which ones should we not, or send to court directly?
If I may just understand, if I understand the question, they're basically asking which matters should not or are not suitable for ADR, right?
Yes.
Okay. Matters that are
Which
not suitable.
Which one is suitable for mediation, arbitration, and litigation?
Okay. I feel like it's, I'm thinking of my students and I know it's probably they're in the chat trying to ruin my reputation. Anyway, what I would say is this: having introduced ADR as methods outside court, let me first of all divide this for you. Some matters are just suited for court. Let's say this: some matters are only suited for court. For instance, matters of a criminal nature are not exactly suited for court. I know Kenyans want to come in here and argue about the case of Babu Owino, who attempted to shoot murder, allegedly attempted to murder someone, and the case of Mohammed in Garissa, where our family picked camels in exchange for basically to have an accused person released. Those are just 3 examples, but generally criminal matters are not suitable for ADR, and very few jurisdictions, very few countries will accept that. Second, issues of human rights, and when you want to assert your constitutional rights. For instance, your right to privacy has been violated, your right to housing, like even under Article 43 of our constitution, our social economic rights. Issues of rights, when you want them asserted and so that they are pronounced that these rights have been violated, those are not suitable for ADR. Where there's a clear imbalance of power, and that is why I also reiterate issues of defilement, and even sometimes in civil or commercial agreements, like for instance, employment. Some employers are multinationals and you are just a janitor. Do you really think you can negotiate at the same level with that person? I don't think so. Go to court where there's a clear imbalance of power. I'm just trying to think. Also, when you need to set legal precedent, and legal precedent in this case is the system that is common law systems basically use, where when a higher court makes a decision, it binds the lower court. So then now this means if the Supreme Court of Kenya says today from Kenya, we allow same-sex marriages, Court of Appeal and High Court cannot say no, that is the law. So that if it's a decision that you want to have binding effect on other courts, you cannot take it to arbitration and mediation or any ADR, because you remember ADR is a private process. It is between the two contracting parties, or the contracting parties generally, and the third party resolver. So then now at that point, the decision or a settlement agreement in a mediation or an arbitration cannot really bind the entire public or exert or enforce public rights. Mediation, arbitration, what goes between now the two, because I've told you litigation, what is more suited, mediation, arbitration. Okay. I honestly find that mediation is better where you want to preserve parties' relationships, and also mediation is faster compared to arbitration and less formal. You see now, the mediator does not make a decision, but the arbitrator makes a decision, as you learn tomorrow. And also, an arbitrator takes evidence just like a mediator. So if you, now for you, it is for you to decide how long do you want your process, your dispute to take in resolving, what kind of control do you want, how formal do you want it to be, how much money are you willing to spend, because arbitration is usually more expensive than mediation. When you look at such factors, those are the factors now that can help you decide whether you want mediation or arbitration. I hope I have answered you. Any other question?
Okay, there's another interesting question here. The person said he has encountered a case where an employee contract was terminated without due process. Employee tried to get audience of the proprietor to appeal, but proprietor denied employee audience. So the employee filed the case in court, and the employer did not file defense, but rather he asked for negotiation. They reached agreement, but one of the managers came up with the allegation that the former employee was a thief and that they are conducting investigation. So negotiation was cancelled. The former employee proceeded with court proceedings, and after 2 years got judgment and damages, and the investigation did not yield anything positive. So the proprietor is now calling him back to negotiation table. Can such negotiation hold when there is already a court judgment?
Okay, now, that's a good one. Okay, what I know from experience is this. I'll say this: ADR processes can happen in 3 ways. They can happen before the dispute, during the dispute, and even after the dispute. Now, the problem with after the dispute is this. In this case, you're saying that the court has already passed, or rather handed judgment, and I'm sure you have your own judgment or orders of the court, but then now the former supervisor is calling the former employee, sorry. Now this former employee has 2 options really. As I said, you can go to a negotiation. It's what basically we were taught in school. You can go to a mediation or a negotiation, but no one is forcing you to settle. Now, in this case, because I've seen even in arbitral awards or even in court judgments, people wanting to go to the mediation after the event, usually it is to discuss perhaps the terms of payment. The terms of payment, for instance, the court awarded 1 million plus interest. So someone tells you, okay, can we negotiate on interest? Go and listen. My advice would be just go and listen why they're calling you back to the table. But to be honest, at this point, since the court has more impetus, I think you have more say here. In fact, in this case, you have the highest bargaining power. So going and listening is not an issue. The issue is, what are you going to be told there? Because the judgment of the court is the judgment of the court. There's nothing that can be changed there. Because also you can go there and they can make yourself admit things, and then they go and appeal based on the things you admit. So when you go there, go and ask yourself, what am I going to be told? No one is going to force you to do anything, because at this point you have an agreement, a judgment.
Okay, let me just take 2 more questions so that you can wrap up for today. There's a question. What is the role of a lawyer in the process of amicable resolution of disputes in commercial contracts? Maybe you can take that with, what are the regional mediation and arbitration? What are the regional mediation and negotiation bodies or platform available in Africa?
And the first one was?
The role of a lawyer in the ADR process. I think you can just take those 2 together and then we'll wrap up.
Okay. On the role of the lawyer, come to my class next week on Thursday. But nonetheless, the role of a lawyer in ADR is simple. First of all, to explain, and that's why lawyers must understand mediation as the first point of call, to explain to the client what mediation is and what the process is about, and what the work of a mediator is, and what kind of mediation it is. Is it court annexed? Is it the ones that you are just ad hoc? What kind of mediation? Second, the role of a lawyer is to help the clients, or rather the parties, to prepare the dispute. To help draft the settlement agreement. 2, to demystify areas of law for the client, because a mediator is not allowed in any way to explain to parties the interpretation of law. So to explain to their parties what the law says on certain issues. Third, I'd say I have the whole, I wish that's a whole class, but yeah, I'm just thinking off the top of my head based on what I know has to be done day to day. And also to advise, sometimes I find that parties tend to be more, by me, I'll send a comprehensive answer to that can be sent out with material on the role of a lawyer. It's a lot, but you see, it's off the top of my head. I just know them in stages, and since it's a short question, I will send that one. And as to regional bodies in Africa, we have too many that I can't name them all, but I'll just say in Kenya, we have the Chartered Institute of Arbitrators, we have Nairobi Center for International Arbitration. Those are our main bodies here that deal with mediation. But if you're thinking specifically of mediation training centers, we have about 6 mediation training schools, Strathmore Dispute Resolution Center. We also have Chartered Institute of Arbitrators, Nairobi Center for International Arbitration, Suluhu, Utatuzi Center, Dispute Center. Center for Dispute Resolution, and Mediation Training East Africa. Those are the 6 that I know are the main ones, 6 to 7 now. I can quickly answer the question from Emma Wanjiru. Element of screening, did I mention involve? Yeah, screening means basically nowadays when you file a case, that case is screened, like it is referred to the mediation registry in Milimani to see its suitability for ADR. But nothing stops you, even if you have a case in court, from going to the mediation registry and asking for your case to go to mediation. Role of a lawyer, Clive Chiro, you're also my friend, I can answer you, but I'll send the comprehensive. Abayomi, I'm just trying to take at least 2, 3.
Not a problem.
Regional mediation negotiation bodies or platforms available in Africa. Oh, those 2 I'll have to send with material because it's a whole list. It's comprehensive. Each country has their own bodies. Can a mediator ask one party to step out so that he can talk with the other side as a way of reaching to an agreement? That is basically the concept of caucusing. However, you have to explain to the party that you're sending out that you're just trying to explore the dispute and you're not favoring this side. And also the party that you remain with must be comfortable to explore the dispute, because you also have to assure him or her that you will not share anything without his permission with the party that is going outside. Another thing also, the party going outside, try and make it creative so that you give them a task. You tell them, just go and think around this clause and tell me how you felt on this and this day, how your relationship, because that he does not feel idle, because an idle's mind is the devil's workshop. When he walks out, you don't know, he might think, let me leave this mediation, or start thinking funny things. So it's always good when you send the other party, one party, when you're in caucus with one party, basically the other one, you give them a task. I think, negotiator requires good communication. Yes, any ADR communication is everything. As I said, just try and hone your mediation, your negotiation skills. Oh Lord, these are many questions. What else? I'm just trying to see which. The ones who say look nice, thank you.
Okay, so maybe what we'll do is to
I don't just one question. Yes. Kindly, process of being Quaternext mediator in Kenya, kindly go to the judiciary website. The process is there, judiciary website, go under Quaternext mediation. The process is simple. Have your 40-hour mediation training, then you'll see the form and the requirements. Yeah, I think I can't say anymore. The rest, yeah, that was a lot. Yes.